couple of minutes for some more people to join us. Okay, just let these last few people come in and then we'll get started. Okay, so good afternoon, everyone, and welcome to today's Lunch and Learn session presented by Children and Families Across Borders. Today, we're going to be focusing on how to navigate complex issues that can arise in international kinship care. My name's Angela Mays. I'm the Local Authority Engagement Manager here at CFAB. Our presentation today is being delivered by our Senior Legal Advisor, Dr. Maria Wright. And we're really excited to have so many of you back with us this afternoon and hope that you'll find the information presented today really useful in your work. It's nice to see that so many of you are joining us again after our previous Lunch and Learn sessions that we hosted throughout 2023. For those of you who might have missed any of the live sessions that we've previously delivered, we'll make sure that we send out links to the recordings of those events along with today's sessions when we're done. Before Maria gets started, I just wanted to give you a brief introduction into some of the services that CFAB can offer you. We're the CFAB's the UK branch for International Social Services. We have access to partners in over 130 countries around the world. We're experts in social work in an international context, cross-border child protection cases, care proceedings that require cross-border cooperation and overseas placements. We can offer guidance and practical support on cross-border children and family cases. If you require any support or assistance, you can call our free advice line. It's open Monday to Friday from 10 a.m. to 3:30. The numbers there available to you on the screen. We also provide casework services, which include issuing child protection alerts, completing record checks, welfare visits, and full assessments. We can provide pre and post-placement support services, family reunification support, and we've just launched our new Life Story service. CFAB's training programme can provide you and your organisation with in-depth content that relates to international child protection, kinship care, best interest assessments for unaccompanied children. And you can also find information there on how to complete our specially developed international social work certificate. I would urge you all to take a visit to our website once the session's finished, just so you can find out a little bit more about how CFAB can support you with your cross-border cases. The website's full of resources for you, including free fact sheets that are available for you to download, as well as our newly launched Cultural Family Life Library. These are introductory guides we've created for social workers on the history and culture of families of Romanian heritage and Jamaican heritage. You can also view our International Kinship Care Guide, which is our good practice guide for professionals placing children from local authority care with family over abroad. Thank you so much for your time this afternoon. I'd like to pass you over to Dr. Maria Wright, our Senior Legal Advisor, for our Lunch and Learn session, Navigating Complex Issues in International Kinship Care. Thank you.
Thank you so much, Angela. And thank you to everyone for coming today. It's really so exciting that everyone's here, such large numbers, and I hope that you'll find the session useful. So what I'm going to present about today are complex issues in international kinship care, and what I'm trying to do is to draw together some of the issues I spoke about on 2 previous occasions. So we had a Lunch and Learn session on overseas assessments, and another one on placing children in kinship care overseas. And I'm trying to sort of consolidate all of the things that I spoke about on those occasions into one session, looking at a case study. So thinking about how we might apply some of those things in practice, how they might arise. I'll be providing a lot of information, but you're welcome to ask questions in the chat, and I will take questions at the end if there's time, which I'm sure there will be. So firstly, I wanted to outline some of the key messages from the sessions I delivered previously. And my aim was to give a kind of structure or a roadmap for the way that a case might progress, where an overseas kinship placement is a potential option for a child. There are always unexpected and unforeseen issues in these cases. And that's primarily because of the huge differences in each country's procedures and domestic child protection or family law systems. And so what I say is not necessarily going to apply in every case in the same way, but what I'm hoping is to try and outline some of the issues that can arise so that we can anticipate them at an early stage and be ready to deal with them. And overall, I think there were 5 key messages from my previous sessions. Firstly, the need to identify issues relating to the child's immigration status and nationality at an early stage before embarking on the assessment process. And I'll explain in a moment why that's important. Secondly, to consider the relevance of the 1996 Hague Child Protection Convention to the child's situation. So where a child will be moving to a country which is, like the UK, a contracting state to the 1996 Hague Convention, this may mean that there are additional options for cooperation with that country via the central authority, and that there's also the possibility of using the convention to recognise any order made in the UK placing the child with a kinship carer in that other contracting state. Thirdly, to think about methods to be used to assess the prospective carer, bearing in mind the need to have an assessment which is both legally compliant and culturally relevant. And that is a phrase which I've borrowed from the Family Justice Council's best practice guidance on special guardianship. And there is a section within that guidance dealing with international placements. And I think it really sums up the aim in these cases, obtaining an assessment which is legally compliant and culturally relevant, but that can be quite a difficult thing to do. And so I'll be saying shortly that it may well be necessary to use more than one method to achieve this. Fourthly, if the child will be placed in kinship care overseas, what will the legal framework for that placement be? So will you be exploring mirror orders so that the carer's parental responsibility is replicated, recognised in the country where the child will be living? Or will you be looking at recognition, which can be achieved under the 1996 Hague Convention? And I'll be speaking more about how that can work in practice shortly. And finally, post-placement support. So what kind of post-placement support will the child need and how will that be arranged? And I've put that at the end, but really it's something that needs to be considered throughout and probably at the assessment stage as well, because addressing it at the end may be too late. And so all of these issues, I hope that we can sort of draw upon as the case progresses. And let's have a look now at a case study to see how these issues might arise in practice. And so this is a case study involving a little girl called Anna. This is a fictional case study, but it draws on some of the different experiences we've had at CFAB in dealing with international placements. So Anna is 6 years old. She moved from Italy to England with her mother when she was 4 years old, because her mother had formed a new relationship with someone in the UK and her father remained in Italy. Care proceedings were issued following an incident of domestic violence in the home, and Anna was removed into foster care. And during the proceedings, Anna's maternal grandmother, who lives in Naples, has told the local authority she wishes to care for Anna permanently. So here we have a situation where if Anna can't be returned to the care of her mother or be placed with her father, we may be looking at a kinship placement in Italy for Anna as a form of permanence. So whenever we're working with children who have international connections, we need to think about their nationality and their immigration status in the UK. And this is going to be important in all cases because they may need support and assistance in regularising their status in the UK if they will be remaining here permanently. But also, where we're thinking about a child potentially moving overseas into kinship care, we need to think about the child's potential immigration status in that country. In this example concerning Anna, the immigration implications of a placement in Italy are perhaps less complicated because Anna's lived in Italy previously. But if you're exploring an overseas kinship placement and the child is not a national of the country they'll be moving to, you may need to explore whether they'd be able to live there permanently under some form of visa and how this could be achieved. And this may also involve considering the immigration status of the potential kinship carer overseas. And the reason I raise this is because some of the more complex inquiries we deal with at CFAB actually involve British families where a relative has relocated overseas and is in a position to care for the child, but the child is not eligible for citizenship of that country or any kind of visa which would permit them to remain there permanently. And in these cases, it may be necessary to explore the placement by way of inter-country adoption rather than an international kinship placement. And if this is the case, you'll want to know that right at the beginning before you start on the assessment process. We also increasingly have inquiries at CFAB about children being placed overseas with carers who do not themselves have permanent immigration status in the country in question. So there can be really complex issues around the child's potential immigration status in the country where this placement is being explored. And historically, what we've seen are immigration issues being considered right at the very end of a case when looking at the practicalities of a child moving overseas to live with family members. And if there is a really big immigration problem at that stage, it can cause huge delay or potentially can mean that the placement can't proceed as a kinship placement. So this is why we emphasise the importance of looking at this issue at a really early stage. The other issue to consider in the context of a child having foreign nationality is that it may be appropriate to notify the relevant embassy that care proceedings have been issued concerning a child with foreign nationality. And I won't go into this in detail today, but the guidance document I've linked to here discusses this practice further. I'm sure many of you are familiar with it, and including the fact that it will not be appropriate in every case for every child, but it is something to bear in mind where a child has foreign nationality. To clarify immigration issues in this context, it might be appropriate to make inquiries of the relevant embassy, the consular section of the relevant embassy. More complex individual issues may require advice from an immigration lawyer qualified in the relevant country. And I should also flag the fact that some countries don't allow dual citizenship. So if the child is going to be acquiring a citizenship of a country that they may be relocating to, you may need to consider the impact on any existing citizenships that they hold. I would also highlight that from our experience, there are countries where if the child is not a citizen of the state that they're moving to, that may impact on their ability to access certain public services, or there may be charges for accessing certain services. And I suppose if we think about access to state-based services in the UK, sometimes a person's immigration status may mean that their access to certain state benefits or services is limited. Similarly, the same may apply if, in other countries as well. And so this is an issue to really think about more in the context of a child's access to post-placement support services and general services if they're going to be moving overseas. Our partners at CFAB are usually quite well placed to consider these issues in the context of assessment, which I'll come to shortly. So if we return to Anna, let's think about Anna. Her immigration status is somewhat straightforward, as she is an Italian citizen, although her immigration status in the UK should be clarified as well, because this could be relevant to her future if the court decides that Anna should remain or return to the care of her mother or remain in some form of alternative care in the UK. The local authority notify the Italian embassy of the care proceedings, and the local authority complete an initial screening assessment of the grandmother, and this is to identify her willingness to care for Anna and her broad circumstances. But it's necessary to explore this placement further. It's necessary for there to be an assessment. Anna's father's unwilling to care for Anna, and there are no other family members in the UK. So we're in a situation now where we need to explore whether this placement is going to be in Anna's best interests, which brings me to the subject of assessment. One of the issues I flagged at the outset was the need to consider the potential relevance of the 1996 Hague Child Protection Convention in these cases. And this can be relevant in the context of assessment. So the 1996 Hague Convention is an international instrument which applies between the UK and a number of contracting states worldwide. You can check the countries where the convention has entered into force on the HCCH website, which I've linked to here. But all EU member states are contracting states to the convention. And there's lots I could say about the 1996 Hague Convention and its relevance to cross-border cases involving children, which I don't have time to today, but it's an instrument which is relevant when thinking about assessing a prospective kinship carer in another contracting state. And the reason for this is that every contracting state to the 96 Hague Convention has a designated central authority. And in the UK, we have central authorities in England, Wales, Scotland, and Northern Ireland. And central authorities can cooperate with each other and promote cooperation between competent authorities. And competent authorities is the term used in the Convention to refer to authorities which are responsible for taking measures to protect children. So, for example, in the UK, depending on the context, our competent authorities for the purposes of the convention could be our family courts or could be local authorities. So where we're exploring a potential placement in a country which is also a contracting state to the 1996 Hague Convention, we know that that country will have a central authority. So this means we can make a request for cooperation through our central authority, which will be transmitted to the overseas central authority, usually to be processed by the relevant competent authority. So that may be the local authority equivalent in that country. And so I've got a diagram here of how that might work in practice. There are lots of different scenarios where it might be a good idea to initiate some form of cooperation in this way. But for today's purposes, we might think about using this route to request that the overseas child protection or child welfare authorities undertake an assessment of a relative's suitability to care for a child. And this might fall under Article 34 of the Convention, which provides that competent authorities can request information relevant to the situation of the child. I should caveat this by saying that each contracting state interprets the scope of the Convention differently, and some contracting states may not accept requests for assessment under the Convention or may require assessments to go through a different route, but a large number of contracting states will accept requests for assessment through this provision. So if we return to Anna's situation, we can identify that Anna's grandmother is living in Italy, which is a contracting state to the 1996 Hague Convention. So this means that the local authority could make a request for cooperation through the English Central Authority to the Italian competent authorities and ask them to undertake an assessment of Anna's grandmother to see whether her home environment would be an appropriate one for Anna to live in, see what her circumstances are. This would give us an assessment which is compliant with Italian law, which is important for reasons I'll explain shortly. And it will be a culturally relevant assessment because it is completed by a professional who is based in the country in question with knowledge of the local context. But it's not necessarily going to produce an assessment which is compliant with our domestic regulations for kinship placements. So if, for example, a special guardianship order is being considered for Anna, this will not necessarily give us an assessment which is compliant with the special guardianship regulations. So we may need to think about other methods for assessment as well. And other options might include an assessment through CFAB. So these will always be culturally relevant assessments because they will be undertaken by professionals who are based in the country where the child will be living or may live. The extent to which they are legally compliant assessments will depend on the partner. CFAB's partner in Italy is a dual qualified English and Italian independent social worker. So her assessments will look a lot like the assessments that one would encounter in care proceedings, for example, when there is an assessment of a potential special guardian in the UK. Other options which might be explored in terms of assessment are the relative in question may be invited to travel to the UK for an assessment. This would not give an insight into the relative's home environment that the child might be living in, and this would not be a culturally relevant assessment on its own, but it may mean that the social worker with direct knowledge of the child can do the assessment. There may be an opportunity to observe the child with the potential carer as well. We're often asked about UK social workers travelling overseas to undertake assessments, and I think this is probably less common than it used to be, but you may well be aware that there can be legal and ethical challenges with UK social workers practicing overseas, and we have set some of these issues out in our fact sheet, which is available on our website and is linked to here as well. So what happens in Anna's case? Well, there were 3 methods used to assess Anna's grandmother in this case. Firstly, the local authority made a request for cooperation via the central authority under the 1996 Hague Convention. And this request was made to the English Central Authority and then transmitted to the Italian Central Authority, who in turn sent it to the local authority equivalent in the relevant region in Italy where Anna's grandmother was living. And they undertook an assessment which was positive, but it was brief. But it was an important step that was taken in Anna's case for reasons I'll explain shortly, relating to the need to obtain consent to place children in other contracting states under the 1996 Hague Convention. In addition to this, there was an assessment using CFAB's partner in Italy, which was positive and comprehensive. And the grandmother also travelled to the UK to spend time with Anna, and the social worker was able to observe this. So we can see here multiple methods being used to obtain an overall assessment, an overall evidential picture in a manner which is legally compliant and culturally relevant. But it would have been difficult to use any one of those single methods to achieve that aim. Another issue to bear in mind when you're considering a placement in a contracting state to the 1996 Hague Convention concerns the application of Article 33 of the Convention. And Article 33 says that where a placement of a child is contemplated in another contracting state, it's first necessary to consult the competent authorities of that state by transmitting a report on the child with reasons for the proposed placement, and the child should not be placed until the competent authorities have decided themselves whether the placement is in the child's best interests. And Article 33 refers to placements in a foster family, kafala, which is a form of alternative care used in countries with a Sharia law system, institutional care, or analogous institutions. However, we know from our experience at CFAB that many contracting states consider that placements in kinship care at the end of care proceedings, for example, including under a special guardianship order, require consent using the Article 33 procedure. And Article 33 is an important provision because a failure to follow this procedure, if it was required, is a ground for refusing to recognise the order placing the child in that placement under the 1996 Hague Convention. So it can be quite a complex provision. There is some guidance on the Article 33 process, which I have linked here, and CFAB have developed our own fact sheet on it, which you may wish to consider. Maybe it's helpful to think about how it might have operated in Anna's case. So we have these assessments of Anna's grandmother of the placement, which have been positive. And so at this stage, the local authority and the parties are contemplating that Anna may be placed in Italy in the care of her grandmother. So the local authority have already received a positive assessment from the Italian competent authorities following their request for cooperation under the 1996 Hague Convention. And they then make a request under Article 33 of the Convention for the Italian competent authorities' consent to place Anna in Italy with her grandmother. And that is directed through the central authority. And because the Italian competent authorities have already undertaken an assessment, they are in a position to agree that the placement is in Anna's best interests. If the local authority had not already gone through the central authority for the assessment, the Italian competent authorities might say that they would need to, at this stage, conduct their own assessment to decide whether to provide their consent under Article 33. So that might cause some delay if that step needed to be taken. Again, I should say also that every contracting state will have a different procedure for receiving Article 33 requests, for conducting assessments under the 96 Hague Convention. So it is a really good idea to make early inquiries with the relevant UK central authority if you do have a case where there will be a potential placement in a contracting state to the 1996 Hague Convention. So let's think about the legal framework for Anna's placement. Again, the 1996 Hague Convention is relevant here. So under the 96 Hague Convention, a measure taken in relation to a child which falls within the scope of the convention should be recognised in all other contracting states by operation of law. So on the face of it, if the court in England makes an order placing Anna with her grandmother under a special guardianship order or a child arrangements order, that order should be automatically recognised in Italy without having to do anything further. And that falls within Article 23 of the Convention. So that sounds great, but actually at a practical level, it would probably be quite difficult for Anna's grandmother to present an English court order to authorities in Italy and expect it to be automatically accepted that she has parental responsibility for Anna and so on. And it's also important to think about the fact that special guardianship is quite an unusual status, and it may not be familiar in other jurisdictions due to the distinct rights it gives a special guardian in relation to the child and the child's parents. And so we can't necessarily assume that authorities overseas will automatically recognise without any difficulties an order made in this country. And under Article 24 of the 96 Hague Convention, it is possible for any interested person to seek confirmation or a declaration that an order is recognised under the 1996 Hague Convention. So this provision is designed to provide certainty that orders will be recognised under the convention. So there will be a procedure in Italy for Anna's grandmother to seek the recognition of an English court order confirming her care of Anna. There are also grounds upon which a court may refuse to recognise an order made in another contracting state. And those grounds are contained within Article 23 of the Convention, and I mentioned one already, which is a failure to follow the consent procedure in Article 33. But the procedure for recognising an order made in another contracting state is governed by the national law in the country where recognition is sought. So in some countries, they have really good systems where it's possible to achieve recognition via the central authority. So you can send your order to the central authority, it's then transmitted to the relevant central authority in that country, and then sent to the relevant court and registered, and that's the end of the process. In other countries, an application needs to be made to court for recognition. And actually, this is the case in England and Wales. If someone wants to apply for the recognition of an order made in another contracting state, they have to make an application to court here. So the exact procedure for seeking recognition will depend on the country's procedures, the country's national procedures. In some cases, it may be better for the child and for the carer to have an order made under the family law system of the country where the child will be living, which confirms the child's care. So we would refer to these kinds of arrangements as mirror orders. Mirror orders will need to be explored in cases where children are placed in non-contracting states to the convention. And we also see them being used in some cases where a child will be placed in a contracting state to the 96 Hague Convention, rather than going down this recognition route, where recognition would not provide an adequate solution for the child. So we do see them happening in 96 Hague Convention states as well. In an ideal world, it would be helpful to have advice from a lawyer qualified in the relevant country as to the best possible legal structure for the child's placement. And where mirror orders are required, this will always be necessary. For placements in contracting states, the central authority may have information about the recognition procedure under the 96 Hague Convention. So again, it can be useful to make inquiries of the central authority for information around the legal framework for placing a child in another contracting state. So I just want to say a few words about post-placement supports. And this is a difficult topic to say anything specific about, because the support that a child will need and the services that are available will be so specific to the individual child's situation. I would say that sometimes we encounter assumptions that other countries will have a system for support for children who are placed in kinship care. And that is not the case more often than not. So if we take the example of Pakistan, for example, we were recently asked about the extent of post-placement support for children in a particular region, which would be provided by the state-based child protection authorities. And many child protection services in Pakistan are dealing with children who have been orphaned or who are homeless or who are suffering the effects of poverty, and are not in a position to provide kind of therapeutic post-placement support services to a child placed with family members after proceedings in this country. And so it can sometimes be quite difficult to find out what is available in the other country and eligibility for services. CFAB's partners can often deal with these issues in their assessments. So if you seek an assessment through CFAB of a potential kinship carer in another country, you might want to ask as part of that assessment that there's consideration of some specific services that might be available in the prospective carer's local area. Our partner in Pakistan, for example, when providing their assessments, will often provide quite comprehensive information about psychological and health support services which are privately funded and what the costs of those are. If support is going to be provided by the local authority, including financial support, it's worth remembering that the carer will need to know who to contact about this, particularly if they have not been made a party to the proceedings resulting in the child being placed in their care. And they may need relevant documentation, and that may need to be translated into their first language. We also find that it can be really helpful to advise the relevant child protection services in the country where the child will be living of the child's placement. So you may have already been liaising with the relevant child protection authorities through the assessment and placement process. But if you haven't, or if the child is being placed in a non-contracting state to the convention, for example, we see this happening quite effectively for placements in Nigeria in particular. The 1996 Hague Convention also contains a provision in Article 30 which says that central authorities must provide information as to the laws of and services available in their states relating to the protection of children. So through this provision, you may be able to find out some general information about what is available to support a child moving to a contracting state to the 1996 Hague Convention. In Anna's case, post-placement support was arranged. So the best option for Anna seemed to be for the Italian court to make an order confirming that her grandmother would care for her under the Italian family law system, rather than going through the recognition route under the 96 Hague Convention. And the reason for that is that would open up access to services from the relevant child protection authority in that region. That court order took some time to be issued, so it took about 4 weeks after Anna relocated to Italy. And then what happened was, after it was issued, the Italian Children's Services decided that, in fact, post-placement visits were not required, and that Anna's grandmother did not need the training that was initially proposed to support her in caring for Anna. However, in this case, CFAB's partner in Italy was able to assist by completing some post-placement visits to see how Anna was settling into her placement and provide some general support to the grandmother to assist with that transition. And we gave this example here because there was a plan for Anna's post-placement supports which didn't come to pass. And luckily there was a contingency for Anna to an extent, because our partner was able to step in and provide some of the support that was required. But I think it's important to think about all possibilities when post-placement support is going to be provided, when an overseas authority will be providing it, and think about potential contingencies if possible. So that was all I wanted to say. And the end of Anna's story. I will just see if anyone wants to ask any questions. And we will be sending out a couple of polls as well. So if you don't mind answering any polls, that would be really helpful for us in planning our, oh look, I can see them popping up on the screen now. So if you wouldn't mind completing a poll about how you have found our lunch and learn sessions and suggestions for future ones, that would be great. I'll leave you, unless anyone does have any questions, with our contact details for our advice line and our website. And what I would say, on our website in the resources section, we have a lot of fact sheets which deal with all of the issues I've discussed today, In particular, there is a fact sheet on placing children overseas, a fact sheet on placing children in non-contracting states to the 96 Hague Convention, which I haven't really spoken about that much today. And finally, a link to our International Kinship Care Guide, which contains a lot of information about how children can be supported in moving into overseas kinship care placements, transition planning and contingency planning, as well as dealing with some of the legal issues that can arise in these cases. And so, unless anyone wishes to ask any questions, I will end the session. And thank you all so much for attending. And if you didn't mind completing the polls, we'd be really grateful, and slides will be circulated. Thank you so much. Have a lovely rest of the day.